March 27th, 1 p.m., I will call the meeting of the Select Board to order. Note this meeting is being televised, streamed, or recorded by Bourne TV. If anyone in the audience is recording or videotaping, they need to acknowledge it at this time. Don't see anyone. Use of flash photography during Select Board meetings is prohibited. If anyone from the public wishes to access the meeting, they can do so by calling the conference line 1-929-205-6099. The Zoom meeting ID is 838-7859-1399. Password is all capitals workshop. The Zoom chat will not be monitored. Participants who wish to speak must raise the hand icon until the chair asks them to unmute. All items within the agenda are subject to deliberation and votes. First item on the agenda is public comments on non-agenda items. Public comments are allowed for up to a total of 12 minutes at the beginning of the meeting. Is anyone here for public comment on a non-agenda item? Seeing none, moving right along. I will note that Melissa Ferretti is on Zoom, and along with our town council Brian Bertram and Ivrea Freed, and present are Anne Marie Saronian, Peter Meyer, and myself, Mary Jane Mastrangelo. Jared may be late. All right. The policy workshop with town council on marijuana. There are several agenda items related. And the first is policy process for developing draft marijuana review procedures. I don't know if there's anything town council wants to say or board members have to say on this issue. Anne Marie.
I'd actually like to get a handle on specific policies that we are required to have. I know we'll need something relative to, multiple applicants for limited licensure. But also the social equity piece, whether we're required to have a policy on that or whether we just have to have the recommended, transparent practices to promote social equity licensure. Because it's a question that's been asked, but nothing specific. I've seen draft social equity policies for some communities, but I know some of those communities are identified as disproportionately disadvantaged communities. Legal counsel can help with that regard, or any other policies that they foresee as being needed through this process.
Do you have any comments from town council on whether those are required or
Brian has his hand up.
optional?
Mm-hmm.
I've got my hand up. I think this is probably a good opportunity for us to jump in and just talk a little bit about that framework and the options. I'm going to be a little bit of the talking head here as my partner who's with me, Ivrea, is really sort of the internal guru when it comes to marijuana licensing, which is why we pulled her into the workshop. So I'm going to be quiet, and I think I'll let her take the lead on this part, but I did want to introduce her to everyone.
Okay, welcome.
Hi, so thank you for having us. I think before I dive into what we think is legally required, I want to make clear that we're still sort of in flux a little bit. The Cannabis Control Commission has issued some recent guidance on what our host community agreements should look like, and they revised their guidelines for communities around host community agreements. We expect to have additional guidance on social equity policy obligations. We had some guidance prior to October when the new regulations were promulgated, but we don't have anything post regulations. So, we can give our best interpretation of what the regulations currently say and guide the community as best we can. But to the extent that new guidance from the commission is issued in the near future, we will of course continue to update the board and revise our guidance accordingly. So I just wanted to give that preference that we don't have as much from the commission as we wish we did at this point in time. So in terms of obligations, for equity, the regulations say that a municipality is presumed to have satisfied the obligations of the social equity policy if they do one of three things. And one of them is adopting an ordinance that would permit social equity businesses to have exclusive access to these licenses for a 3-year period. The second is to adopt a model bylaw or ordinance governing social equity that's issued by the commission. They have not issued one at this point in time, so we don't have anything to share with you on that. And then the third is to create a local approval process that for equity applicants that is administered on a one-to-one basis with non-social equity applicants. So those are sort of the three things. If you do one of those, you're presumed to be in compliance with the social equity policy. Now, presumptions can always be overcome, so query, whether you don't, a community can still be in compliance if they don't do one of those three. Our position would be you could, we just don't know what that would look like yet, and we're waiting for more guidance from the commission. So in addition to doing
Can you,
one of those three things,
just wait. Can you explain what this local approval administered on a one-to-one basis with non-social equity, what does that mean?
Yeah, so what it basically means is that you may choose to administer a one-to-one local approval process until such time as 50% of the applicants are social equity. So what you would do is you could give one license to a social equity applicant and then one to a non-social equity applicant. You couldn't give all three to non-social equity applicants. You would need to go social equity applicant first, then you could do a non-social equity applicant. It'd have to be on a one-to-one basis.
And then
So that's what we have for.
does the third one then have to be social equity? Or could it be either?
So, I think we could take the position it could be either. The regulations say that until such time as 50% of the licenses are social equity. We don't really know. I think
Okay.
we could talk about it further if that's appealing. You could do two social equity to be conservative, and then we wouldn't have to argue that your policy is in compliance because you would be meeting that 50% threshold.
Okay.
So you would want to reserve, in that case, I guess you could reserve two for social equity applicants and one for non-social equity applicant.
Okay.
And we can discuss further as we move through what other requirements you have. We'll talk about the grading rubric and how you can weight social equity applicants.
Okay.
So in addition to one of those three things, a host community needs to adopt what they're calling transparent practices to promote and encourage full participation. And so one of those is having a website. Lots of people have talked about this, identifying on your website how you would apply for a host community agreement, how you would apply for local zoning approvals, who would be responsible for facilitating that process at the local level. Basically, a one-stop shop for someone that's interested in operating a marijuana establishment in your town. And then in addition, you need to adopt a social equity plan. And so, like you said, many communities have been issuing drafts or kind of going through this process. Our hope was that the commission would be releasing guidance on what should be included in a social equity plan. We have some guidance that predates October when the regulations were promulgated, but we do expect something more definitive to come from the commission. So while I think it's prudent for Bourne to think about what they would want to include in their social equity plan, we just want to make sure that we continue to view our plan as a live document and revisit it if and when the commission issues something that suggests change would be appropriate. And then the third thing that communities must do is they must come up with some type of scoring rubric that you will utilize to consider and evaluate host community agreements to the extent you issue them. And I pause there because while Bourne may decide to issue host community agreements, you are not obligated to do so. You can give waivers. And so to the extent you have decided to just not require a host community agreement, an individual that wants to operate in your town would just come in, get their waiver form, and then move forward to the local zoning approval process. But if you are going to issue host community agreements, then you need to develop a standard evaluation form. The evaluation form must be posted online. And we don't know a ton about what this evaluation form needs to look like. We don't have any guidance from the commission in detail yet. But what we do know is that the regulations say that not less than 25% of the overall evaluation score must be towards social equity. So they want you to weigh social equity very favorably in your metrics. Now, in terms of timeline,
Wait. Excuse, we have a question. Anne Marie, go ahead.
Just for the general public, can you define what constitutes social equity?
I wish I could give you a quick answer to it. So it's defined by statute, and what it essentially means is that you're an individual from a disproportionately impacted community, and that you are Black or brown, or you have had a drug charge in your past that is listed in the state regulations. Most of the time they're drug offenses, marijuana drug offenses. So what it doesn't mean is majority minority owned businesses. That doesn't get you across the threshold unless you fall into one of the other, one of the specific categories. Or a majority woman-owned business, for example, is not a social equity applicant as well.
Thank you.
And so I think maybe just ending with the timeline obligations. So we have May of 2024, you are supposed to have these policies in place. The commission is authorized to start fining communities that are not in compliance by May 1st of 2025. An interesting and yet to be evaluated provision of the regulations say that the fine shall equal the total amount of community impact fees collected in the prior year. Now, query what would happen if a community is not collecting community impact fees, as many communities now are deferring and not collecting any fees. So what would the fine be in that case? But like I said, a question for another day, but did just want to flag those key dates for the board. And so what we are finding helpful to kind of help communities move forward in this process is to think of these in sort of three camps. One is, do you want sort of just a kind of a freeze to say, for a period of time, let's only look towards social equity applicants? Is that something we want to entertain? Do we want to have a one-to-one type system where we're going to reserve some for social equity and keep some open for non-social equity applicants? And then in terms of our policy, what does our policy look like? What are we valuing to ensure that there is really open compliance? So in Bourne, I'm not sure what it would look like specifically, but some communities, for example, are making sure all of their materials are available in many languages. If there's a dialect that's spoken in a particular community or a language that's spoken there, they're making sure that the materials are available. So you would want to look within your own community to see what is relevant for Bourne. And then in terms of the rubric, the scoring metrics, this is what it is very important for you to sit down and think about what is important in our community. What are we looking for here? Are there areas of town? Is location really important to us? Is the quality of the applicant really important? reported to us, how are we going to value these host community agreements to the extent that we are going to issue them? So I would, maybe start with the larger picture and kind of get down to the nitty gritty. That might be one way of managing this discussion today.
Any comments, questions?
I wonder I know this may not be the right time for it. I know at the last meeting, we talked about setting an RFP process, and then we heard that an RFQ process,
I think that's just a naming convention. I think what we're doing, I don't think we're doing an RFP process per like 40B, we were just calling it. It's a request for proposals or qualifications. We're really asking for qualifications and what their plan is, so I don't think that's a major
okay,
distinction. I
Okay.
mean,
all right,
what we end up asking for is really things that are gonna qualify the applicants.
yeah,
What the comparative criteria that we've talked about is ownership and, foreign resident ownership, documented business experience, industry experience. Are they a social equity applicant? Are they a disadvantaged cabinet applicant?
understood,
Are they a certified empowerment applicant, whatever that is?
Yep.
Do they have an employment plan? So those are all the qualifications. They're not really, that's what we're really asking for, and so I think that's semantics more than anything else.
okay. Yeah,
So, you gave us some sample rubrics for, Boston, and, do we have to, if we say something like owners or Bourne residents for at least 5 years, or 3 out of the 5 years, do we have to have specific criteria defined for scoring, or can we leave it up to the select board to award 0 to 5 points based on their own discretion? How specific do our comparative criteria have to be?
That's a great question, and one that, we're hopeful the commission will help provide additional guidance on. Right now, what we do know is that 25% of the total evaluation score needs to be directed for social equity applicants. So an easy way to make sure that you're meeting that requirement is to say, okay, we're gonna grade this on 100. And so social equity gets 25 points, location, gets 25 points, quality of the applicant gets 25 points, and use those numbers. And maybe there's many factors that go into reaching an ultimate conclusion, but I do think having a numerical grading system would allow us to demonstrate compliance with the 25% requirement in an easy, defensible way.
okay.
And just to add, the ones from Brockton and Boston, I'm not suggesting that those are models that Bourne should adopt. We are in the infancy of standardized evaluation criteria forms, and so there are just not that many communities that have already promulgated some. These are just 2, and so we need to find a model that works best for Bourne based on what Bourne values here in its community.
Does anybody have any thoughts on that?
So based on our criteria categories, we'll call them, or criteria, we have 4, right? Location, ownership, business plan, and safety security plan.
Right.
So are you saying that each of those could be 25 points total for each of those categories to add up to 100?
Well, we have to put in
Sorry.
social equity as one of those categories.
So currently within one of our criteria, where it says ownership, we reference the social equity as part of the comparative criteria, but it's one of 6 comparative criterias for that category, ownership. So I'm just trying to figure out,
Yes.
so,
My advice is that we have a separate category that is just social equity that gets 25% of the overall score. And you can break that down. You know, the regulations do have some guidance on what would go into that. You know, do they qualify as social equity applicants? You can also consider things like, are they, you know, Black, African American, Hispanic, Latino, Native American, Indigenous, you know, so we can talk about what goes into that category. But I think from a conservative standpoint, to make sure we are in compliance with the regulations, the advice would be to have a separate social equity evaluation and to not nest it underneath another category.
okay.
And Brian, I want to give you an opportunity to chime in there as well.
Can we say within, oh, okay, no, never mind. Go ahead, Brian.
I'm just gonna say, I agree wholeheartedly. I think, you know, if we're ever asked to show that we have complied with this, it's just so much easier to say, you know, 25 points, here it is, we did it, we're good.
Okay. What can we delineate in that specific category of social equity other than, like, that it's, you know,
Is that either a 25 or a 0? I mean,
yeah, is it, can we further delineate, like, so let's say we have 3 applicants that are social equity, right? How do we qualify those applicants within this social equity, separate social equity category to further, you know, look at who's a better applicant, or who, you know, will serve this community well or fits in well with the community? How can we do that
Right.
with that
And-
category? Or it's just
Right.
it's just a checkbox, and then they're compared to all the other criteria we have? Is that how it's going to work?
Right, so, yeah, so we may be using social equity, or I may have been using social equity in a fluid term, so 25% needs to be targeted towards equity, and so within that, we have social equity, we have economic empowerment, we have different races, so we can kind of have some flexibility under that equity requirement. However, if you have a social equity applicant and you have another social equity applicant, it's very possible that both of those applicants are going to score 25 on your equity component. And so then it comes down to location and the other factors
Okay.
that Bourne deems significant. So this social equity applicant is proposing an establishment, you know, outside of town in an area where the police don't really go that often. We don't like that location. We'd much rather it be over here. And so we're gonna score this one a 10 and this one a 25. So those are the other factors that you're going to get to look
Okay.
at.
That clarifies things. So it's basically just a checkbox. They automatically get 25 points ahead of anybody else because they fit that box, that criteria of social equity. And then we can
Exactly.
compare them to the other applicants with respects to our other criteria. Thanks.
Absolutely. So a non-social equity applicant wouldn't be able to qualify for those 25 points, and you know they may score perfect on all the other ones, but a social equity applicant, you know, may win the day based on the scoring metrics.
one thing I'll say about location for our particular situation, I'm not sure if you're familiar with the marijuana overlay district that we did our zoning for. The planning board spent a long time identifying certain sections and certain parcels that qualify, some just by site plan approval on MacArthur Boulevard, which is Route 28, and the other sections by special permit. So location, as far as I'm concerned, doesn't get a lot of points in the comparative criteria because there's a big requirement that they be in the MOD, so I wouldn't put a lot of weight on location. I mean, in terms
Yeah.
of the comparative criteria. it's a kind of a small factor. I mean, we had business plan, which incorporates a lot of, whether they have adequate funding, whether they have experience, whether they have, they have an employment plan for residents. So there are factors in the business plan that would be like a 25-point category. If we had 25% category for social equity, the ownership piece of it, are they a resident or have they been a resident in Bourne? And then some of the other certified, are they a certified?
Economic empowerment.
Economic empowerment goes to social equity, right?
Right.
But the things like a disadvantaged business enterprise, a minority woman, veteran, so some of those categories are gonna be non-social equity categories, but could be in the ownership category, as part of that,
Yeah,
right?
yeah, and I think once we understand more about what is significant and important to the select board and the town, then we can try to craft a grading rubric that adequately reflects your goals. So absolutely, we can tweak this to fit your needs. If location isn't something that you think needs a significant weight, we can weight other areas more heavily.
Yeah, so we had location, ownership, business plan, and safety and security plan. And I might put like 10 points for location and then 15 for the security plan. But do you like social equity, business plan, ownership, location, and
Those are larger,
security? And then, yeah, we're done. And on a
Do you mind
100
if I
point scale.
tease out a little bit? Do you mind if I tease out a little bit what you mean by safety and security plan?
Okay.
The reason I ask is that the Cannabis Control Commission has pretty strict requirements on a lot of that, and so I'm not sure we're gonna see as much diversity
Oh,
amongst
actually, we didn't have
applicants and
we didn't have any comparative criteria for that.
No,
All
just,
that,
it was
what,
just.
and I sent our sheet to you, and, so we had, under safety and security, we had really minimum document requirement, that they have a draft security plan, that they give us an agreement that they're gonna work directly with the police, and that they're gonna give us an agreement that they're gonna have periodic reviews with the police in accordance with the final security plan. So we really didn't have any comparative criteria, so we could,
It's just documentation.
yeah, we could maybe split up the business plan into like 2 different categories. Because that's not gonna be a comparative, that's gonna be or like add 15 points to
Well,
something else.
does the Cannabis Commission require, when the applicant applies, they require strict security plans? Does that include it having to be reviewed or with the police department? Is that a part of a requirement?
It is.
It is, okay.
So the CCC works with the local police department on
You
that.
have to, if you're gonna speak, you have to
Sorry.
come up to the,
Yeah, so the attorney's absolutely correct that the CCC has control over the security plan, and that is, when it gets to the local level, then they work together with the police department, and the police department will look at the plan and whatnot. And for practical reasons, you don't necessarily want your full security plan out there to
You
the
don't.
general
No,
public.
no, that's, yeah, no. Would
So
be-
that's the security plan, and
Okay,
there's some other things I wanted to speak to when the time's appropriate.
okay.
all right.
So, I mean, maybe we just say in the minimum requirements that they'll work with the police and they'll have reviews and they'll just agree to that. In our documentation, when they're sending in their proposal, that they'll agree to that in advance, so we don't have to worry about it. Melissa, you wanna make a comment?
Yeah, no, just a comment. Yeah, I know in the research and, this is complex as Ria spoke. I hope I said that right. As the Cannabis Control Commission, there is a lot of information on their site. But one thing I did notice in the research, of course, as that there was a lot of redaction when it came to security plans online. So it would talk about a little bit about the security plan, but a lot of municipalities redacted all of that information for safety. So
Yeah.
just adding to that. Thank you.
So if we look at Boston, I mean,
MJ, can I ask a question?
sure, go ahead.
So, one of my questions is, what are the town's abilities to, control changes of ownership over time? So if a social equity applicant comes in and is 51% majority ownership of individuals who are social equity program participants, that's a snapshot in time at when they're applying. But after they've received their license and after they're operating, what ability do we have to control the changes of ownership later?
Yeah, so I have to get back to you on the answer to that question. My memory of the regulations is that it's very limited, but I want to make sure that I'm answering that question appropriately so we can follow up with an email. I'm sorry that I don't know the answer off the top of my head to that question.
Is that something that would be in the host community agreement?
So
Yes.
so my memory, so I do want to check this, is that historically communities included conditions in the host community agreement that if an ownership change were to occur, that it needed to be approved by the select board. And there was pushback from the cannabis community on those terms. And so my memory of the regs is that they address this in a way that limits the ability of communities to restrict transfers, but I want to follow up with an email because I don't recall the scope of your authority off the top of my head.
MJ, this is something that I just want the select board to not lose track of, because over time, it's going to change. And if all of your decision-making is based on a point in time and that is completely changed after a couple of years, I think we have to talk about that.
Right, and that would be interesting, that direction, the Cannabis Control Commission should be giving direction on that. Because if they don't want to limit the transfer, then it could be easily become someone, makes a business out of being the social equity applicant and get you in there, and then you get bought out like 2 years later, and it's not social equity anymore. So it would seem to be that they would have an interest in making sure that social equity, people that are granted a license based on social equity maintain that somehow, that kind of status in the future.
Yes, I think to play devil's advocate, prohibiting social equity applicants from transferring their license, it limits their capital, right? They build a business, it grows, and it's successful, and they want to sell. They should be able to sell just like any other. So yes, it could potentially impact your quota or the amount of social equity licenses you have within your community, and you may have to take certain actions in response to that. But I think that prohibiting transfer also comes with a set of negative issues that the commission was trying to deal with.
I was thinking more along the lines of a liquor store license. That has to be, the select board has to approve the transfer, but they have to have grounds for not approving it. So you couldn't just say, well, you can't transfer it, but yeah. Steve?
Absolutely, and like I said, I'll follow up with an email, but I do want to say, there had been originally a lot of comparison between cannabis and alcohol, and I think post-October, those similarities are a lot fewer, and the amount of control at the local level over cannabis is greatly reduced, and you have much more authority in the liquor context.
Interesting.
And what Brockton did is they have a requirement that you have to be up and running operational for a full year before the license could transfer to somebody else. So the rationale behind that is a social equity applicant doesn't come in, get a license, and then just sell it off and go on to the next one. So maybe that's something that we could look at. Thank you.
Yeah, and so one of the problems is that a lot of things that cities and towns have done in the past might not necessarily be kosher now. And so it's really, we're in this like point in change and, if we don't have control, if the Cannabis Control Commission says we don't have control, then we don't have control. They have to approve the license transfer, right? Do they have to approve the license transfer?
Yeah, they do.
Yeah.
They do, they
Yeah.
do.
So
yeah.
we leave it on them.
Like,
Okay.
Right, but yeah, then that, we'd have to figure out the proper language and policy though, right?
That, I think would have to be part of the HCA. I think that's part of the, because it was, what was the other thing?
But if we have a policy that encompasses the social equity license,
But is it only gonna be for social equity licenses, or is it any transfer?
well,
So if we have no control over that, I mean, we have to, let's see what she comes up back with. Because there are other things, if they have a special permit and they lose their special permit, like, how do we terminate? If they're, what kind of provisions can we make for sale or transfer? So those are HCA things that we need to have in terms of our HCA. I think, and for the HCA, we are only allowing retail marijuana establishments and retail, and treatment center, medical, but we don't allow, any other we don't allow growing, manufacture, we don't allow any of that stuff in Bourne. So when you look at the model HCA, there's all that list of what are you applying for. I think our list should be like 2. Like, I'm applying for this or
Yep,
this
this
or
one.
both. And
Yeah.
on the authorized operations, there's a whole list of authorized operations, and we should just delete all the things that are prohibited in Bourne, so there's no confusion where people think on our form. So the specific location, and then we have to agree as a town on what current occurring fees are, and then we need to decide on our annual permit or license fee and the process for establishing that, which I don't think should be too difficult.
One of my questions about the annual or the recurring, maybe not annual, but the recurring fees is, we don't have any obligation to list any fees that are not under municipal control, do we?
no. Just fees that you collect internally in your town. What, is there something you're thinking of specifically?
So we have wholly independent water districts. I would not list on the municipal website a water bill. They are not under the control of the municipality.
Okay.
But
Sorry,
if
go ahead.
there's a tax bill, if they own property, there's a portion, on your property tax.
I would list property tax.
So property tax, CPA, and there's a water district tax that's added to your tax bill.
So when we list them out, I would list property tax, personal property tax, those types
Yeah.
of things.
Okay.
Those are issued by the municipality. The town of Bourne does not issue water bills.
Right.
I don't want to get in the situation where we start listing things that are not
Ours.
from us.
Right.
Yeah, from the municipality.
So the portion of the
And, you know-
property tax that's the water district tax on a property bill we would list, but we wouldn't list the usage bill that
I
comes
would
directly.
list property tax bill. I wouldn't break out CPA, I wouldn't break out any of those. When we list, what do you expect, what are the regular charges you expect a property tax bill?
Okay.
I mean, do we have to break down every special assessment on our property tax bill?
So we don't have guidance from the commission. I would say that it's appropriate to just say property tax bill. If you know that your property tax bill includes special assessments, we could make a note on the host community agreement. We could also reserve certain rights, saying, you know, your property tax bill may include special assessments like betterments to the extent they're applicable. So we can kind of work with the town to make sure we're protected as possible so that the regular recurring fees are identified.
I would want to keep a lot of flexibility in that, because if things change, I don't want to be, you know, we can't necessarily chase down.
Yeah.
Yeah, so I think that idea of special assessments.
Yeah.
Because what
Yeah.
if we did a wastewater infrastructure fund?
Right.
So we don't want to have to go back and
Yeah.
change it,
So I don't
In special
want to,
assist, yeah, okay, so that kind of,
but not specific, not itemized.
right, yeah, that makes sense. Is there anything else we should be thinking about in the HCA in our template?
So I think the termination provision in the model HCA is not sufficiently protective of communities. I think you've already highlighted that, so I would make sure that we visit that. I also feel like the description of the establishment and what the operations, the planned operations could use more detail. You know, I think those are sort of the key areas where I'm seeing a lot of communities diverge from the model. If there are other things that you would like to see, we can talk about whether I think they're defensible under the regs and whether or not they should be included. I just want to say, you know, to the extent we make changes to the model, we're going to potentially have to defend them in front of the commission. So we want to make sure we've really thought them through.
Yeah, I mean, I definitely want the specific location listed, not the, whatever clause they have in it now that's like location to be determined or something, so I definitely want the specific location to be listed, and, I don't know, whatever kind of establishment they're planning on doing,
Right.
yeah. Okay.
And I guess another question for the select board is your intent to only issue 3 host community agreements, or is your intent to issue as many host community agreements as you want, or deem proper, and then it's up to those individuals to obtain the special permit? Because the cap is on the special permits, the cap is not on the host community agreement. So potentially you could issue your RFI and get 6 responses that are all very interesting, and you could issue 6 host community agreements, execute 6 host community agreements, and then it becomes basically a race for each of those individuals to obtain the zoning relief they may need. So you don't need an answer now, but another thing for.
I would be inclined to issue 3 and then have them go through the
Licenses.
process, and if they didn't complete the process within a specific amount of time, maybe entertain more. I don't want to, I'm not inclined to have a race to the planning board, that, especially since we've had this question come up about what constitutes a completed application to the planning board, and our zoning says that you need a signed HCA for a completed application to the planning board, but people could people could kind of jumpstart ahead and try to go to the planning board and get approval, so,
Pre-approval.
and I'm not sure that that's a correct procedure. I think I've asked a question about that, so we need to get clarification.
Okay, so I think if that's the case, which it's an appropriate answer, we just want to make sure that the HCA reflects a provision along those lines. Like if you haven't obtained your special permit or your site plan approval by X date, then the host community agreement shall terminate unless there's good cause. Or if you obtain your zoning relief, but it lapses for non-use within as specified under our zoning bylaw, then the HCA shall terminate unless there's good cause. So we want to just make sure that our termination provision reflects the goals that we're setting out to accomplish here.
And so
That makes sense.
we would have to put some sort of timing into the HCA for when they would need to get their site plan or special permit approval?
Permitting
So it'd be
process.
contingent on site plan, special permit within a certain amount of time?
You could, I mean, it's really a policy decision. I think that's an option. The other option is you just say, you know, unless you're operational in X number of years, then this lapses, you know, we can kind of
Okay,
look at all the different options. You know, it's what Bourne wants ultimately is the decision. And we just want to make sure whatever you want is reflected in the host community agreement, because I just want to be clear right now, that goal is not included in the model in the way that we're talking about it today.
so do we have an opinion on this?
What about if filing for an extension? You know, I know you're saying it has to be done within a certain amount of time, but sometimes things happen and they go, and they file for maybe a one-time extension, like similar with the planning
Yeah, I
board.
mean,
Well, yeah, there
Yeah.
could be language in there in the event the planning board has to, for whatever reason, extend it to another date, then I don't think that's a
what's a
problem.
reasonable amount of time to get,
Yeah.
to be operational? 1 year?
So operational is a harder determination for me to make than obtaining planning board approval. So I think a planning board, it would be reasonable within 4 to 6 months, provided that they have everything lined up and are moving forward. I think a year gives them plenty of time to get all of their local approvals necessary. The reason I'm hesitant to give an operational is that the Cannabis Control Commission's process can be extremely time consuming. And so while I've seen some applicants move through quite quickly, others have gone slowly for what I would say no fault of their own. So, you know, I think operational within a year and a half may be what we would see, but I would just be hesitant to give guidance without further thought to see what other communities are doing.
Lois's answer.
I think tying it to your process makes the most sense. Because if they fail to obtain your local approvals, they're not getting the state licensure, right? Like the local approval is the key here.
Cert of occupancy is how we've seen it.
Well, to get a CO, you have to be, I mean, that's kind of the operational thing.
Right.
But that's just a builder, Steve. That's not for your cannabis license.
Yeah, and if we do it operational.
I'm just trying to, instead of saying we're gonna keep saying, we're gonna decide this later, I'm trying to get something down in a draft where we say, this is what we're gonna do. We can,
Yeah,
it's still a draft, but let's draft it in a way
Right.
that makes
I'm more
sense.
inclined through the permitting
Yeah.
process
Yeah,
than to
Melissa,
wait for.
what's your comment?
No, I was just gonna, just add, and I just had a quick question. I was just curious. Obviously, we are not going that route. I know that there are some municipalities that have not decided to use host community agreements and go through the Cannabis Control Commission. What does that process look like? What is the timeline for something like that? Is that a quicker, obviously it's a quicker process because you're not going through all of the special permitting and the town situation, but is that a quick process normally if it's a community without any of this in place? Is there a timeline they usually get this done?
So I don't know the exact answer to your question on whether the timing is shorter, but what I do know, is most communities have some type of zoning review. I'm not aware of a community that allows by right marijuana citing. And so even if you're avoiding the host community component, which I think many communities are, because it's not fitting for their town or city, they still have to go through the local process, and some communities have an additional layer of a local license, which is different than a host community agreement or zoning relief.
So, but
So one option,
the way our zoning was written, they have to have a signed host community agreement to have a complete application to the planning board for a site plan approval or special permit. And that's required. They have to have a site plan, the location in the MOD where they have to be requires either a site plan or a special permit. So they need to, so we have to have a host community agreement, or we'd have to have a waiver, and if you're gonna do a waiver, you might as well do a host community agreement. They have to go through the planning board process, and then if we have a license, that's the time when we can ask them for a fee. So once they have their HCA, they go to the planning board, they have their planning board approval, then they're qualified to go for a license, in which case they can wait until they've got their cannabis control license. I mean, they could do that process and then come to us and say, okay, we've got our cannabis control license, we're ready for the Bourne license, and then pay us the fee for the Bourne license, and then they're good to go. That's
Okay, that wasn't for me, right? Because I know that already.
Yeah.
Correct. Okay, just making sure.
Well, I mean,
I knew all that. I
yeah, but you
understand,
you
but I
asked
wasn't
if,
sure if you were talking to me or if you were.
no, but I'm just clarifying the process. I mean, you asked if they could skip the signed HCA and the zoning, but I think in the way our zoning was written, you can't do that.
No, I wasn't asking if we could skip it. I asked what would the timeline be for towns that do? That was my question.
Okay.
Yeah, thank you for clarifying.
And something to just note, I think that process is exactly what's happening, but most of the time we're seeing the Cannabis Control Commission application being filed at the same time that the local the local zoning relief application is filed. And in some cases, even the commission license has predated the zoning relief license. So those processes sort of go simultaneously. The commission won't issue a final license without the zoning relief sign, because they need to go through and see the build out and stuff like that, but they can get a provisional license at some point, even without having the local licensure, the local zoning relief in hand.
Thank you so much for that. I appreciate it. Thank you.
Okay. Is there anything else? So where are we on that? Let's go back to the HCA. If we're drafting our HCA, we're gonna remove some of the inapplicable things that we don't allow in Bourne. We're gonna have a specific location. We're gonna put in our generally occurring fees. We're gonna look at something about termination, language suggested from council. We're gonna think about what we can do for the provisions for sale or transfer. We're gonna get that from town council. We're gonna get a description of the operation and the location. We're gonna have something that talks about, that the HCA can be terminated, if they don't, have a planning board planning board site approval in 6 months, or they're not operational. I'll give them more time. I mean, sometimes like trying to be operational could be a long time. Let's say they're not operational in 2 years, and then, unless they come for a waiver, or make it 1 year and say unless they come for an extension.
Is that an and? Is it zoning relief within 6 months and fully operational within 2 years? Like, is there are there targets along the way, or is it an or?
Well, I thought there was some hesitation because of the lengthy process that the Cannabis Control Commission can have, that it would be an or. That as long as they're through the permitting process, and have language with respects to that timeline, right? Giving
Right,
specific
the 6
timelines with
months.
extensions, as opposed to saying you have to be operational in 2 years.
That's
So
fine.
That was my understanding.
zoning relief within 6 months or fully operational within 2 years?
Or,
Or not have language, do we need language about operational in the HCA?
I don't know. If we don't care, if we're gonna do a signed HCA, they're gonna go to the planning board, and they're gonna get their relief. If they're not operational in 2 years, do we wanna be looking for someone that's gonna get operational, or are we gonna give them forever?
yeah, but if they're not operational because of no fault of their own, it's one
Well, we
thing.
can give them an extension if they come to us,
Yeah.
but,
Yeah,
but if they're, I mean, I can't imagine anyone sitting on the license, but if they did,
I can't either,
yeah,
but things happen,
right.
so.
I guess thinking back to my old planning board days and how things will get extended out at times, so I just want to have
Well, it's,
provisions.
yeah, but I said with, unless extended by
Yeah.
the select board.
So,
That- and
or,
if I may, that's the problem in some other communities. Taunton, for instance, there are 3 licenses that were given out over 5 years ago, and they're still not operational to this day, and they have no policy as to how to pull these licenses back, so they're kind of stuck in the middle of it. So, you know, as far as operational goes, 2 years sounds like a reasonable number, because that, you'll know at the end of 2 years where you really stand. So from the operational aspect, I say 2 years. From the local standpoint, I mean, if you give a host community agreement out to somebody on June 1st, you know, everybody's ready to file, or most people are ready to file at the planning board. They'll file June 2nd. They'll be on for sometime
Yeah.
in June. Then, you know, you get a decision, June, July. You get a 20-day appeals period. Then it comes out, you record your decision. So the 4-month for the planning board sounds like a very reasonable period of time, too. And they have their own timelines. When you file with the planning board, they have to make a decision.
I'd give them 6 months.
Yeah.
Just, you know, like a safety, I don't want people to come back and
Mm-hmm.
say the planning board, you know, they were sick, they couldn't get a quorum, I don't know, whatever.
And that makes
So I
sense.
go,
Yeah.
planning board 6
Right.
months, and, I would say, and operational within 2 years. So you get your planning board in 6 months, and you're operational in 2 years, unless extended by the select board.
That's perfect.
That's fine,
okay.
yeah.
Yeah, I echo those comments. We represent a community that has a license that's just trapped. And so we want to make sure that we have provisions within our host community agreement to claw it back if necessary.
Right, because, I mean, we only have 3, and if someone, I don't want someone sitting on a license, I want them to get going and get operational and be in business.
Right.
Melissa?
Yeah, I just want to piggyback on that. I think we, as a select board, need to make sure that we don't have any licenses that could be obviously that are hanging in the wind when we have prospective applicants who could, you know, be utilizing the license and opening a business on hold. So I completely agree that we as a select board need to put something in there. Thank you.
So if we say and, does that mean either is a disqualifier?
Yeah, you have to do both.
You have to get the planning board in 6 months, and if you don't do that, you're
And
out.
operational in 2.
And you have to be operational in 2 years.
You
If
have to
don't do
meet
that, you're
both
out.
on, you have to stay on track the whole time.
Yeah, I like that.
Unless extended by
Unless extended by the
by-
select board, who come and say,
majority.
for good reason. Okay. All right. Is there anything else we should think about for the HCA? Can you guys start working on that now?
We can start working on it,
Okay.
with the caveat that once you see it, you guys can decide whether additional terms are necessary.
Right. Yeah, I think that would be good. Let's kind of get that going. Okay. So, do we want to look at, say, the Boston criteria and talk about our criteria and whether, we want to try to, like, flesh out some of our scoring?
Well, let's look at the criteria. Are we in agreement that we need to add a social equity, separate criteria for social equity, right?
Yes, for 25% of whatever the ranking is.
25%, 25 points, whatever scale we
Right.
use. As long as it's 25%.
So I just want to confirm, you're ruling out you're ruling out the 1-to-1 option, and you're ruling out the 3-year hold option. Right,
We're not adopting an ordinance permit.
We're
for
not
a
doing
3-year period.
exclusive.
We're not
We're not
doing
doing
the model
exclusive.
bylaw, there's a supposedly model bylaw.
yeah.
So we're
So
we're
we
doing
can-
it based on the local approval process,
Okay.
basically.
So we can
So it
remove
is on the
those.
one-to-one kind of, right?
It's,
It's not the 1-to, there's those 3 tracks, right?
right,
So I think you need to rule out the 2.
yeah,
We're not doing exclusive.
no,
No.
we're doing it by a local approval process.
And it's,
If we call
and
it
she said
one-to-one or-
administrated one-to-one basis So one is social equity, one is non-social equity, and then the third one
Can be any.
may or may not be
Probably should
social,
equity.
yeah,
Yeah.
unless, you know,
So the third part of that is adopt the bylaw that the commission will issue, and we don't know what that looks like yet. So, you know, we anticipate that that's the path most communities may take,
that makes sense.
but we just need to see it.
Yeah. Do we know, are they meeting like this week or something to do that? They seem to meet once a month and like, you know,
Yeah. So I don't know the answer to that question. I haven't seen anything that suggests they're moving forward in that direction. I would anticipate that they're going to hit the May 1st deadline. You know, they came out with the, you know, a lot of the model host community agreement right before the March 1st deadline. So my guess is that we'll see something right before May 1st, which is very helpful for this town meeting, so.
yeah. So I think that's good. I think we'll try to do the model bylaw, and then if there's.
So do we need to hold something on the warrant? We can't, I mean, how
Oh.
can, yeah.
No, I wouldn't put anything on your warrant. We can do it in the next annual cycle. Like I said, what are the fines if you're not collecting collecting community impact fees? I think, you know, you're making progress to meet your goals. If we need to hold a special, we can talk about it, but I wouldn't put it on your.
Does it have to be does it have to be a bylaw or could be a model ordinance policy? Is number 2 only a bylaw or is it?
Well, an ordinance is for a city.
It's
form of
adopt an
government.
ordinance or a model bylaw, yeah. We're not a city, so it wouldn't be an ordinance, right?
So does that kind of by default mean that if we're doing marijuana licenses this summer, that if we don't have a model bylaw adopted by town meeting and we're not doing exclusive, that we'd have to do it 1-to-1?
I think so.
So what, it means we're not presumptively in compliance with the
Okay.
regulations. That's what it means.
Okay,
You gain the presumption of being in compliance if you do one of those three
Okay.
things.
So what if we have, what if we move forward, you know,
Right.
with the comparative criteria and an HCA issues, but the model bylaw isn't adopted or contradicts in some fashion?
well, let's see what the model bylaw says. I think we'll kind of know whether the model bylaw is going to fit what we're doing. And what's not clear to me is if you have a rating scale of 100 points, right? And you give the social equity people 25%, but they still aren't the highest scorers, do you still have to choose them
Ye-
on a 1-to-1 basis? So I think we'll have to kind of go with we'll have to see what they say in May for the model bylaw and whether or not.
I think we should see. I think that's true. I do say, you know, I think a conservative approach would be to accept 1-to-1, right? That's going to guarantee that you're in presumptive compliance, but, you know, whether you're legally obligated to do so is an open question.
Okay.
And Brian and I have talked about this kind of at length, and we just don't have guidance yet.
So, I mean, it could be that we don't do 1-to-1 and we don't have social equity applicants that are scoring high enough to be chosen in our rubric, and
I think if.
then we're not presumed, and then we'll have to just deal with it from then, like what happens.
But I think in that process, though, if there is such a denial that we have, you know, the documentation and back up to say, these are the reasons why,
Why.
and that has to also be very transparent,
Right,
so.
okay.
Is the town able to set a floor? You have to score at least whatever the number is, you have to score at least an 80 to,
So
are
that
we
was-
able to set a floor?
So there's nothing that precludes that in the regulations, and we don't have guidance from the commission that says you can't. My concern would be, how are you weighting certain factors? So for example, if you're weighting experience in the industry very highly, or experience running a business very highly, you may be disproportionately impacting social equity applicants in a way that frustrates the purpose of the regulations. So we need to just be mindful of what results may come out of a floor.
Because in the end,
But
we're
if you
inviting.
get sorry, go ahead.
In the end, we're inviting those applicants. And it could be such that we leave that open, that we don't put a minimum score, and that we are still inviting those applicants to present to the board that we think we should issue a license to. Because for that reason, right, where the social equity applicant may not have a score as high as 3 others, but we want to invite that applicant to the table for further, right?
Well, is that allowed? Or is it just based on is the decision solely based on the numerical
Well, we haven't made that decision,
rubric?
right?
Or is there an interview process afterwards that's more subjective? Because if it's based, I mean, if the idea is that we're creating a numerical grading system that would allow for a defensible argument for compliance, would an interview hurt our defensible argument? So if the entire point of creating the numerical scoring system is to create that defensible
List.
argument, then why would we do an interview?
Well, it's not necessarily interview. I mean, I think part of the process, we wanted them to come to the full board in a public hearing, a public session, to,
So as part of our ranking in some of these, I guess the question is there's a decision to interview people. Do we interview everyone, or do we have certain people we interview? And then if we interview them,
does that impact the overall
is
score?
do we have suppose we're gonna give the interview 15 points, just for, because I had I had 25 for social equity, 25 for business plan, 25 for ownership, 10 for location, and 15 for interview. Do we start with 85 points, and the best out of 85 get interviewed, and then the 15 points for the interview determines who we actually do the HCA with? That gives the social equity people more than 25% in the first round. But not necessarily in the last, not in the final.
Correct,
In the final.
right.
You got a
So-
comment, Steve?
I don't know.
Yeah, I would say a few things on that. I mean, first of all, if you're social equity, you're getting a 25-point head start on everybody else who isn't social equity. To me, that's what's fair under the state's guidelines, what they're trying to do. If that's the only thing you have going for you and you have no experience in the industry and you're otherwise not really qualified, we shouldn't be giving that
Yeah.
license out. So that's one thing. I envision the process that everybody who applies, however many that may be, and we'll certainly get at least as many applicants as we have licenses, I can assure you of that. I would give everybody a hearing. Let them come in and make a presentation to you. Let them make their case to you. And that's when the scoring happens. So when they come in there and they tell you about their business experience, and you meet the people that are behind the scenes and they give a presentation to you, that's when you can really score them. You can't just score them on paper, or at least that's my thought on it. And then the other thing I'm still a little bit confused on is the social equity component. There are a lot of communities that just don't get a social equity applicant. So what I had suggested in the past is that if somebody aligns with those principles, if you have a company that's woman-owned or owned by people of color, but they're not, under the CCC regulations, technically a social equity candidate, can they still get points
Yeah, it
under
comes
that?
under the business, and under the ownership.
Okay,
So under ownership,
Comparative
we have
criteria.
minority, women-owned.
So
It has to be, it's
is
a
that
different
outside the
rating.
25%?
Of
Or is
social
that
equity?
within the
Yes,
25?
It's
no,
outside.
it's outside the
Outside.
25% social equity.
Okay.
Because that's under a different criteria. That's why I asked that question, because they get the 25 automatically. Can we compare them to all the other criteria we have
Right, okay.
with respects to ownership and location?
Right, so the ownership piece of it is the residency in Bourne, the documented business experience, the documented industry experience or industry-sensitive experience, then the disadvantaged minority women, veteran, whatever doesn't go in social equity. And then,
Right.
you know, so those are the ownership points that you can get in addition to the social equity points.
Okay, makes
Yeah.
sense. Thank you.
If I may, I would propose not having a separate interview process. I would recommend, like the last commenter spoke, that you have individuals come in and make a presentation and then you do your rubric. To have something that is just a grade based on your interview is maybe viewed as subjective and discriminatory against
And-
equity applicants, and I know that's not the intent of the board, but I'd hate to end up in court trying to argue that the intent of the board was proper. That's a hard place to be.
Okay,
So then
so
it's-
we interview we're gonna interview everyone. If we have 25 applicants, we'll just interview them all.
Presentation, yeah,
presentations
not-
by
yeah.
everyone, yeah. Okay. I'm still needing, they get 15 free points. We gotta talk about where we're gonna put those. We have social equity, business plan, ownership, each 25, 10 points for location, and then I have 15 points up for grabs.
Well,
Is
are
there
we
anything
doing,
do you wanna do the employment plan as opposed to the,
what, or we do 30, 30, 30, 10? What is the difference?
it's fine with me.
So okay, hold on. Do we, okay, if we do 30, 30, 30, 10, the safety and security plan, do we need that as a criteria?
It's not a comparative criteria, it's only, we're not dealing with that,
So
they're
we're not
just-
scoring that at all?
No,
So
it's,
then-
it's one
so-
of the documented things that they
Right,
agree to
okay.
work with the police and they agree to have, they agree to work with
So
the
it's not
police and
really
they
a-
agree to have it, so we're not gonna comparative on that.
Okay.
I don't
So
feel
then the 30, 30,
competent to do
30,
that as a
10 would
compare.
work.
Yeah. We good with that?
Yeah.
Like that?
Mm-hmm.
Okay.
We meet our 25. 30, 30, 30.
And then we
10.
just have to come up with the definitions, like, sort of parse out the social equity piece, I mean, not the ranking pieces of like, what we're gonna say, you know, are the different factors that go under each of those, and we have some listed out, we can just kind of, you know, equally or not. Is there anything in the Boston thing that we like or don't like, or in the New Bedford thing? I mean, the Boston thing has a lot for like location, which I don't think we, have to spend that much time with, so.
Yeah, that must be, must be
And
something
I
to
think
have
we
to do with
decided
it.
previously that we didn't want to do community feedback, public support as a ranking.
Yeah, no. that's a requirement, the community outreach is a requirement of the regs, of the, so.
Is the,
And whenever that happens, maybe they talk about it when they come in for their interview,
presentation.
presentation, sorry.
Is there anything else that we should be thinking about at this point? I mean, I think. In terms of the scoring.
I think this is a good starting point. It will at least allow us to get a draft pulled together. The board members can digest between now and the next meeting, and if new things are thought of, we can incorporate them and consider them at the next meeting. But I think we have a good list going.
Yep. Is there, any, I kind of like had set out the licensing process with like 11 steps. Some of them are gonna be overlapping. I kind of thought that in our process, when we set out our process, that we're gonna wanna set specific dates.
Yeah.
So we're gonna say, all right, we're open at June 1st, then we're gonna say we're gonna close at June 30th, and we're gonna set out all the dates, so the interview dates and whatever are all gonna be set in advance, so that everybody
Right.
knows what they are, so we don't have to waste a lot of time. I wasn't sure about the public hearing, to vote the HCA, if we're gonna actually do a public hearing. We're not gonna need like posting in the newspaper kind of public hearing 21 days in advance, or are we? No,
I
we're
don't-
just gonna,
I don't think so.
yeah, so we could
Administer
do
the
that, we could
license?
tighten
Is that what you're
up.
talking about? To administer the license?
I'm talking, I had step 8. I had step
Yeah,
7
so-
is notify selected applicants that they've, so interviewing applicants to determine to enter an HCA, notify the applicants, have a public hearing to sign the HCA. So if we've interviewed, we've decided, you know, it's out there in the public, if we're gonna have a public hearing before we actually sign the HCA, where people could come and say, no, or yes. I mean, doesn't have to be 21 days, it could be like 14.
No, I don't think it does.
Yeah, no.
I wasn't,
Yeah.
yeah, tighten that up a little bit, okay.
And it's a presentation, right, and not, are you calling it an interview, or are we calling it a presentation? What are we calling it?
Notify of presentation. So, but we're sort of taking out this meeting to select applicants, right? Because we're gonna present everyone.
Yes.
Okay, so there's not gonna be a preliminary review. There's
No.
gonna be an initial review by staff
Correct.
that's gonna say they've got everything required in there. And then there's gonna be a select board preliminary review and interviews.
At presentations.
Yeah, and their presentations.
Are we doing it on the same day? Are we reviewing and hearing presentations?
We're not even reviewing, we're gonna interview everyone we
So
decide.
so it's not a preliminary review?
Right,
It's just a presentation?
right.
Then,
So this can kind of close up.
we're not having number 5 either, because we're not, that's on the applicant. The community outreach?
Yeah, but so the community outreach,
to know
when you
when-
read the Cannabis Control Commission, they want that to be part of your HCA process. So while we're having presentations and, you know, they should be doing their
Community outreach.
their community outreach meetings. So we should have all the interviews and then maybe have a public hearing to to decide, to hear public comment and vote who to sign HCA's with. It kind of tightens a bunch of steps out of that.
Well, we have to notify
But
those that we
how
have,
many
that,
people, how many interview dates we might need if we had a lot of interviews, a lot of people, a lot of presentations, we might need to do it on multiple dates. So that would need to be a number TBD.
Yeah.
We might set a couple dates. Or like, you know. I'll kind of rework this based on we're gonna invite everyone to make a presentation.
And I guess it depends on how many applicants you really get. I mean, if you get 25 applicants and 6 of them, you know, didn't submit a business plan and like clearly.
Well, they're out
well
then.
thought out.
Yeah, so that we have minimum
Right, like-
criteria that are required. Those,
Exactly.
if they didn't meet the minimum required documentation of a business plan, a location, all the ownership stuff, you know,
within
all
that
those
time
things.
frame.
They didn't properly respond to our request for qualifications, so they're not gonna get interviewed. Or they're not gonna make a presentation because they didn't meet the minimum documentation. It's, the presentations are by people that met the minimum documentation and then will be interviewed for the comparative criteria.
I guess my point is I'm trying to be cognizant of this board's time, so to the extent that you get a lot of applicants, maybe some didn't meet the minimum criteria, but really are never going to make it to the top of the pool, you may be able to do a one round of cuts just based off of the documentation and then invite 5, 6, 7 to give their presentations, and you can choose from those.
Yeah,
those
and
sets.
maybe that step
So we
would
can-
be like maybe there
yeah, we
is
can
of,
evaluate that.
yeah, if more than 10 applications are received, there might be a preliminary. So we get 10 presentations, yeah.
Yeah.
So that step would be only if more than 10. Okay. All right. Move to C, we're moving right along here. Order of applications. Do you guys have any thoughts on the planning board site plan review and the special select board? Have you had a chance to think about that?
The special permit?
Special permit? Based on our zoning? Or do
Are
you
you
want,
asking from a timing perspective?
yes.
So if the requirement is that they have a host community agreement in hand, they won't be able to submit until after your meeting, and then it will run pursuant to the timing provisions outlined in your zoning bylaw. The site plan approval process will go much quicker than the special permit process.
Right, but so the question was that often our planning board starts a public hearing before there's a completed application. So the question is, could the planning board start the site plan or special permit process before having a signed HCA and a completed application?
Based on the language in the bylaw.
We'll make a contingent of. Or can he do that?
I guess I defer to Brian. I don't have an opinion formed yet on that. I know different communities handle it different ways.
Yeah, let me think about that one a little bit. I mean, it would be, in an ideal world, people don't go to planning boards without a completed application, but I also understand that sometimes the reality is a little different, and I don't, and candidly, I think that I need to go back to, I did take, I was involved in a little bit of the review of the draft bylaw. I just wanna go back and make sure, because I think this issue may have come up at some point, so give
Okay.
me a couple.
Well, so
couple of
we'll
days and I'll
defer
get
the
back to you.
answer. You're not ready to answer, so we'll keep thinking, we'll keep that on the list. That's fine. And that goes into the next, determining what defines a complete application, is that next point. So the next thing is establishing a local license and determining at what point it should issue. Is there, do you guys have any frameworks for like people that have a marijuana license? Like this is this is what the license looks like? So can you give us an example of what that license would look like and that process and fees? And like what we can, how much we can charge? Because that fee question, what's a reasonable fee in that? So that, if you guys can give us some input on that, that would be good. The next, if anybody has any comments or questions on the rest of this, let me know. The next is seeking funds from special town meeting to provide resources to draft and create all materials necessary. I'm gonna say that we don't do that. I think we have consulting
Enough.
funds in the town administrator's budget, and I don't see this as being that heavy a lift. I think if we find out later that it was, we can do something different.
Well, if it's unforeseen as you're going down the road, you can always maybe do a reserve fund transfer later and then put the money back in at the special in the fall.
Well, it's not really unforeseen, so.
Yeah, well, I'm gonna say that something comes up at the last
Yeah,
minute.
I mean, we only have from now to the end of the year, and I'm thinking.
End of the
that-
fiscal year.
Yeah, next year if we need to do more. I mean, I think
Okay.
I don't think it's necessary, and I'm not particularly interested in having that discussion at this town meeting.
Sure.
Anybody else have thoughts on that?
No, if we think we're good, we're good.
Nope, my budget is already committed, so I'm fine. I am spent.
Okay. And we don't have minutes. We have to kind of up on minutes maybe. And then future special meeting schedule.
So 2 weeks from today's the 10th, I think. Let's see. Yeah, the 10th and then the 24th. May 1st, I'm not available at all, because a family matter.
Did you suggest April 10th at first?
Yeah, it'll be 2 weeks from today.
Do you think you guys can have some stuff for us for the 10th? And I see Ivrea has her hand up, so you tell us.
We can definitely have stuff ready for you by the 10th. I did want to flag, you mentioned a license, and I know we're using terminology loosely, but do you mean something different than the host community agreement and the special permit site plan approval?
Yes. So we can't charge a fee, right? We're not charging an application fee. We're not charging, they get their host community agreement, they get their site plan special permit, then they get a license, and we're gonna charge them for being a business and marijuana business in town, some amount of money. I don't know what it's gonna be, what's reasonable. And then that would be subject, then it would be like, say it's an annual license that they're gonna pay us every year. And then some of the things that we talk about, employment, what we did talk about, if they were gonna employ residents as part of their annual licensure, they would report back to us about how many employees they had that were Bourne residents, so that we would be able to track that.
Okay, so I just want to flag, I'm not aware of a community that has adopted a local licensure process that didn't do it through bylaw. I can spend some time thinking about what that would look like. It doesn't mean it hasn't happened, I'm just not aware of
Okay.
it happening.
And if we had to do a bylaw for that, then we're gonna be into the fall.
Right.
Yeah. So I would be interested in how we could establish a license without a bylaw.
Okay,
And if we have to do a bylaw, then we have to think about that.
yeah, to the extent it's a bylaw and you have to wait till the fall, it'd be a general bylaw, not a zoning bylaw, so no one would be, automatically grandfathered unless you expressly make them grandfathered, so you could set, within 6 months of adoption of the bylaw, or approval of the bylaw by the AG and posting by the town clerk, you shall obtain, licensure, so we would be able to scoop them in.
Yeah, or we could do it for license or starting next January, so it's the annual, and
Exactly. You could, yeah, you could do
or
it
whatever.
that way as well.
whatever our period of time is. Okay, that's good. So we might not get it immediately, but we would set it up for the future. Okay.
April 10th at 3, so Jared can
Yeah.
Excuse me.
attend.
Yeah, I think that's okay. And that's not our,
It's gonna be tight for me, but I think I can get there.
would you rather a little later, or would that be worse?
She's on mute.
Mute. You're on mute, Melissa.
See, let's just select it.
Melissa, you're on mute.
Oh, sorry, yeah, I have a 1:15 appointment, and then I have a 4:30, so it's gonna have to fit in between there, just make it if there's.
Yeah, we'll do like 3 to 4:30 and then, yeah,
It's fine,
okay.
I'll figure it, just keep it the way it is, don't change it for me, I'll just have to, I'll get back in time, hopefully to log in, it'll be fine.
Okay. Is there any other comment, questions? Anybody else want to say anything about what we're doing here? We're making progress.
I'm good, thank you.
All right, then.
Motion to adjourn.
Second.
Motion by Peter, second by Anne Marie. Roll call vote. Melissa?
Yes.
Anne Marie?
Yes.
Peter?
Yes.
MJ, yes. It's unanimous. 2.